count 1 is dismissed.
Okay.
What starts as a routine court appearance is about to take a dramatic and completely unexpected turn. Judge Simpson is moving through the docket like any other day, handling cases, setting dates, and issuing standard rulings. Nothing seems unusual at first glance. But within minutes, this courtroom is going to shift from a simple retail fraud proceeding into a deeply concerning conversation about addiction, honesty, and personal safety. One of the biggest themes you'll notice throughout this hearing is trust. Judges rely on information from defendants, attorneys, probation officers, and prosecutors to make decisions. The moment that trust starts breaking down, everything changes. As this case unfolds, watch how quickly the focus moves away from the original charge and toward behavior that has the court seriously alarmed. What begins as a request for more time suddenly becomes a much larger issue, and Judge Simpson is about to confront something he believes cannot be ignored.
Defendant is referred to probation for pre-sentence investigation and recommendation. Sentencing in this matter will be January 14th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you. Yeah, thank you. Court does call the case People versus April Fleming.
Ashley Felton, people. Good morning. Assistant Public Defender Warren. Let me just state your name for the record.
Sorry.
State your name.
April Joy Fleming.
I am asking for hopefully one last adjournment. We've been adjourning for medical records. We did get some medical records are waiting for records from Trinity Health. Hopefully I can get that mitigation over to the people and come to it.
Ms. Fleming?
Yes.
Were you huffing on Zoom?
I'm sorry?
Were you huffing?
No, I was not.
Are you sure?
Yes.
So if it was reported to me by 2 people that you were, they wouldn't be telling the truth?
I don't understand what you mean. Was I huffing when?
Today.
Today? No.
Where do you live?
I live at Chittister Place Apartments.
How long will it take you to get here?
I don't have a ride or anything. I don't know. To get there today?
Yeah, today. We saw you doing something you probably shouldn't have been doing.
What do you mean, sir?
Were you huffing?
Was I huffing just now? Like on camera? No.
Okay, today off camera, on camera, you've been huffing?
No.
Not at all?
No.
This is the moment where the hearing starts moving into dangerous territory. Judge Simpson isn't casually asking questions anymore. He's testing credibility. Notice how direct the questions become. The court believes it observed behavior consistent with huffing, and instead of uncertainty, the defendant gives a firm denial. That's significant because judges pay close attention not only to what is said, but also how confidently it is said. If later evidence contradicts that statement, the issue becomes larger than the conduct itself. Now it's about honesty with the court. From the judge's perspective, a person struggling with addiction can often be helped. A person who continues denying obvious facts becomes much harder to evaluate safely. The concern here is already shifting away from legal procedure and toward risk assessment. At this point, Judge Simpson appears determined to get answers directly and in person rather than relying on a remote appearance.
So if you came down here and I sent you over for a test Everything's going to come back negative?
Yes.
It will?
Yeah.
Okay, you're going to need to find a ride. I'm going to need you down here.
Okay, sir. I don't know how I could get there.
Miss Fleming, I'm gonna give you a call, okay?
Okay.
Thank you.
Thank you.
And counsel.
Ashley Feltus for the people. Good. Public Defendant Lauren Perny on behalf of Ms. Fleming. Say your name for the record, please.
Keep it fun.
All right. Well, thank you for coming down. Miss Fleming, I'm going to ask you again.
I did. I was.
You did what?
I huffed.
You were huffing. Yeah.
I'm sorry. I made a mistake.
Why weren't you? Why were you lying to me when?
I panicked. I just panicked. I'm so sorry. I'm really, really sorry.
Ma'am, how frequently are you doing this?
I
mean, are you doing that every day?
Sometimes.
I mean, you're going to end up dying.
The tone of this hearing has completely changed. What stands out here is that Judge Simpson is no longer discussing paperwork, court dates, or procedural matters. He's talking about survival. Once the defendant admits she was huffing, the entire conversation becomes centered on the real-world consequences of that behavior. The judge isn't using dramatic language for effect. He's expressing genuine concern about what he sees as potentially life-threatening conduct. At the same time, the court is wrestling with another problem. The defendant initially denied what happened multiple times before finally admitting it. That combination, dangerous behavior followed by repeated dishonesty, is exactly the kind of situation that makes judges nervous when deciding whether someone can safely remain out of custody. What makes this exchange especially powerful is that the defendant is apologizing and asking for another chance, while the judge is clearly trying to determine whether promises made today will actually mean anything tomorrow.
Can you give me another chance today, please?
Is that what you're trying to do?
No.
Are you trying to kill yourself?
No, I'm sorry.
Okay, but how long have you been doing this?
I don't know. I've tried it off and on for a year or so.
Have you thought that you might need to get into some type of treatment or something? Have you?
I need to.
But you haven't done that.
I guess I haven't had anything like this happen. I plan on getting in touch with.
Who are you going to get in touch? You don't even know.
Huh?
You don't even know who you're going to get in touch with.
Well, I know I have to speak to.
I will say Miss Fleming does go to therapy at Huron Valley Consultants.
Yeah.
As I've stated, we've been working on getting those medical records. I have reviewed some of those medical records. It indicates they do talk, and Miss Fleming's on methadone. We're still in the methadone program. So I do know, I will say that there are entries that they've had these types of conversations about her past use. So I think it's something that Miss Fleming knows that she deals with.
Yeah.
Have you told them that you're huffing?
No. I know I have to. I
Sure.
plan on speaking to my counselor today.
When's the next time you see your therapist?
I can see him tomorrow morning.
Here's where credibility becomes the central issue. The defendant is now describing treatment options, therapy appointments, and plans for getting help. Under normal circumstances, those statements could be very reassuring to a court. The problem is that they come immediately after a series of false denials. That's why Judge Simpson openly says it has become difficult for him to know what information he can trust. This is a common challenge in cases involving substance abuse. Courts often want to support treatment rather than punishment. But treatment plans only work when the court believes the person is being truthful about their situation. The judge isn't simply evaluating whether therapy exists. He's evaluating whether the promises being made are reliable. Quick question for everyone watching. If you were in Judge Simpson's position, would the admission of wrongdoing help rebuild trust, or would the earlier denials outweigh it? That's the dilemma sitting at the center of this hearing right now.
Okay, so Ms. Fleming, here's what you got to understand. For me, when you tell me that you have an appointment, when you tell me all these things, it becomes hard for me to believe whether or not you're telling me the truth.
I understand that.
And that's because I asked you a series of times when you were on Zoom.
I freaked out. I should have said the exact truth. And I'm so sorry, Judge Simpson. Please give me a chance today, please.
Well, Ms. Feltus, you want to say something?
I do, Your Honor. Ms. APA Cook was able to review the YouTube footage, and we shared with Ms. Geary a screenshot that did show the defendant with the canister in her hand. I recognize that canister to be what I commonly refer to as dust off or computer cleaner, a type of compressed air. I'm very familiar with this drug, and I know that any time that you use it, it can cause instant death.
Yep.
This is a drug that is extremely dangerous, and the way that this is being ingested can lead to long-term issues as well as immediate death. The brain can die every time you do this. I think it's clear the defendant's very scared. I think it's clear that she wants to change. She wants to stop using. I really want to see her again, Your Honor. I'm very worried that we're not going to see her again. I truly, truly want the court to hear that this coming in from a place of compassion and concern, not a place of bond violation. Is coming from a place for the people of actual concern. We will not see her. I am requesting that the court consider bond change with a release to treatment for her to get some help. But I do know that my experience with this drug and all the education I have surrounding drugs in general leads me to believe this is an extremely risky behavior. I ask the court to consider a bond change.
This may be the most important argument presented by the prosecution. Notice that the prosecutor is not focusing primarily on punishment. Instead, she's emphasizing danger. Her argument is built around the idea that compressed air inhalant abuse can produce immediate and catastrophic consequences. She repeatedly stresses concern rather than hostility, even telling the court that this recommendation comes from compassion and fear for the defendant's safety. That's a powerful distinction because prosecutors are often viewed as pushing for stricter outcomes. Here, the prosecution is effectively saying that leaving the situation unchanged could place the defendant at serious risk. The court now has competing considerations: maintaining the defendant's freedom while treatment is pursued versus taking stronger action to prevent a potentially fatal outcome. When both the judge and the prosecutor begin expressing the same safety concerns independently, it becomes increasingly clear that this case is no longer being viewed through the lens of a retail fraud charge alone.
Please, Your Honor, please.
I do know Miss Fleming does have a medical team around her. She sees her primary care doctor consistently. As I stated, she is in therapy. I think everyone's concern for Miss Fleming is warranted, especially the circumstances that this arose out of. I'm happy to work with her and get information to the people in the court if the court allows her to stay out of custody. Obviously, if she's in custody, that will take place too. I'm just asking that the court consider letting us work on that while she's out of custody.
Please.
She does have some medical issues that, and that's partially why she sees her doctor so consistently. This is an old retail fraud. I do This case, I don't believe has anything to do with her use or anything like that. I just asked for
Well,
a chance
it
to let
might
something
though,
know.
because if she's been using for off and on, as she's indicated, a year, this offense is in June of this year.
Well, I mean, I don't know exactly how long I've been using it. It's been for some months now. I don't know if it's been a year exactly.
Okay, Ms. Fleming, here's how I know you're an addict. You tell me one thing, and then when all of a sudden that doesn't seem like that goes your way, you change your story. You did that in rather rapid shot fashion when you were on Zoom.
I'm so sorry.
No, Miss Fleming, sometimes things happen for a reason, and not all of them we like what happens, but they happen for a reason. And maybe it also goes to what Ms. Feltes said.
Judge Simpson is revealing exactly how he views this situation. Rather than treating the discovery of the Huffing incident as a random interruption, he's suggesting it may have exposed a deeper problem that needed attention. From his perspective, the uncomfortable confrontation happening in court could ultimately prevent something much worse out the courtroom. The defendant is pleading passionately to remain free, promising she will stop and insisting she understands the seriousness of the situation. But the judge keeps returning to the same obstacle: trust. Every request for leniency runs into the fact that she repeatedly denied the conduct before eventually admitting it. That's why this hearing feels so emotionally charged. The defendant is asking to be believed at the exact moment the court feels least able to rely on her statements. Have you ever seen a courtroom situation where honesty became more important than the original charge itself? That's exactly what appears to be happening here.
Please keep me out of custody today. Please, Judge Simpson, please. I'm begging you.
You can't stop.
I am stopping. I'm done. I promise. I
And
promise
here's
with
my
everything
problem,
in
Miss
me.
Fleming. Miss Fleming, here's my problem. You've already lied to me today, repeatedly. Repeatedly.
I am so sorry. I am so sorry. I got here as soon as you said, please to come down. I got right on the bus and
Well,
I came
it
here.
was either going to be, and I think you understood, if you didn't come now, we were going to come and get you because there was going to be a bench warrant.
Okay. I think you're scaring me straight.
No, I don't think I have. Certainly not yet. But I'm going to let you know, if you think for 1 minute that I'm going to sit here when I know what I know at this point and have you die on my watch, and I haven't used what tools I have to try to make sure that you stay alive, you're sadly mistaken.
Please don't take me in today, Judge Simpson. Please, I'm begging you. Please, please, everything in me, please. Please give me one more chance, please. Please, Judge Simpson.
And I will add, Your Honor, Ms. Fleming was honest with me when I spoke with her. I think she understands the reality of the situation.
Anything else you want to tell me?
The tension is reaching its peak. By now, everyone in the courtroom has expressed concern. The prosecutor is worried. Defense counsel is asking for an opportunity to continue treatment outside custody. The defendant is making emotional promises and even trying humor in an effort to persuade the judge. But beneath all of that is a question that still hasn't been answered. What can the court reasonably rely on moving forward? One of the most revealing moments is that Judge Simpson repeatedly returns to safety rather than punishment. He isn't discussing revenge, anger, or making an example of someone. He's focused on what happens when this hearing ends and the defendant goes home. If the court genuinely believes there's a substantial risk of self-destructive behavior continuing, that dramatically changes the bond analysis. The decision that's coming next isn't really about what happened earlier in the day. It's about what the judge thinks could happen after the defendant walks out the courthouse doors.
Just that I'm going to tell you the truth from here on out. I swear on everything in me. I swear on everything in me, Judge Simpson. I swear on everything in me. And I voted for you.
Doing about the 65 other thousand, but thank you, I guess. You're not dying on my watch, not tonight.
I'm not going to die
I'm
tonight,
done.
please.
I'm done listening. Listen to me now.
Okay.
You're not going to die on my watch. I can't trust you. I don't know what therapeutic routine you have, what you have surrounding you that I can safely let you out. Because whatever you're doing at this point, you do it, you go home and you're huffing.
I won't,
But yeah, I know you're going to tell me I won't do it. You're going to tell me that all that
please, Judge
stuff.
Simpson, please.
Miss Fleming, I've heard it all before. And then the next thing I know, before we even get to your case again, guess what? I'm online reading about your obituary, and I'm not doing it. I'm just not doing it. If they can get the information, I'll take a look at it and I'll potentially reconsider. I'll set a review of her bond on December 22nd, 2005 at 9 o'clock. But at this time, her bond is revoked, defendant's remanded.
I'm arrested? Oh my God.
Get somebody down.
May I appear for Zoom?
Pardon? Yes. Yeah, I was going to say that.
Thank you.
Yes.
The hearing ends with one of the strongest messages Judge Simpson delivers in this case. After listening to arguments from both sides, hearing repeated pleas from the defendant, and weighing the available information, he revokes the bond and orders the defendant remanded into custody. Importantly, the judge makes clear that his reasoning centers on safety. Throughout the hearing, he repeatedly expressed fear that continued huffing could result in a tragedy before the case ever returned to court. He also emphasized that repeated dishonesty made it impossible for him to confidently trust assurances that the behavior would stop. At the same time, he leaves the door open for future review if additional information becomes available. The major takeaway from this case is that credibility matters, especially when courts are making decisions involving personal safety and release conditions. Judge Simpson's ruling was ultimately driven by concern, not simply punishment. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.